All right, welcome. Please sign in to the attendance. I know who you are. It's too easy in this class. Any questions from last class? I know two of you weren't here. If you have any questions from the class, I'd be happy to answer them. No? No? Okay. I apologize. I lecture in that class far more than I would like to, but it's a good way of getting all the information across. Okay. So we're going to be moving on. So far in the first, at least classes like 2 through 6, I think, we've only covered the scope of Congress's powers, right? We've always asked the same question. Does Congress have the power to do X? Does it come from the Commerce Clause, or maybe the Necessary and Proper Clause, or any other provisions in Article 1, Section 8? This next topic, today's class, as well as the class on Monday, asks a different question. The question asked is whether federalism puts a limit on federal power. Whether federalism puts a limit on federal power. Now, again, this is still going to be a question of Article 1, Section 8, right? Does Congress have the power to enact such a law? But the analysis is a little bit different, right? When Congress tries to regulate individuals, people, it's one type of analysis. But when Congress tries to regulate states, both in terms of state legislatures and state executive branch officials, it's a different type of analysis. Everything always boils back to the Necessary and Proper Clause. You'll see that in both of today's readings. But the analysis just is framed a little bit differently because of who's being regulated. Okay? So let's start with a question up here. Who or what can the federal government require to take action? A state official, a state individual, a state official, an individual, all the above, or student's favorite, none of the above. Okay, one more second so we can vote. All right, very good. Let's see what we got. Ooh, we got a little bit of a divide here, right? So, 2 of you put all the above, and 3 of you put none of the above, and no one picked A, B, or C. All right, let's walk through this one at a time, right? So Lindsay, let's start with you. Can Congress require a state to take action?
No.
Okay, in what case?
The federal government wanted to require all of these states to raise their drinking level or drinking age to 21 years.
Mm-hmm.
And South Dakota's was 19. And they disagreed and argued, and it was held that the state could incentivize the federal government could give the state incentives.
Mm-hmm.
They couldn't force them.
Okay, very good. South Dakota v. Dole recognized a principle that Congress can bribe states to do what they want, but Congress can't outright command states to do what they want. And we did a reading today that reflects that, right? Lindsay, what's the other case we have for today that reflects that principle?
That would be New York.
Right, very good. So we have South Dakota v. Dole and New York versus the United States, right? These are both cases that recognize the principle that Congress can't tell the states what to do. All right, Chelsea, so what about a state official?
No.
Can Congress order a state official to take some sort of action?
No.
Okay, and what case tells us that? Very good. That's our reading for today as well. This is Prince, right? Prince versus the United States. Prince concerned whether Congress could require sheriffs, local law enforcement, to perform background checks before somebody purchases a handgun. Okay? And we'll discuss here that Congress can't make people buy. Congress can't make the sheriffs do the purchase background checks. Now the next one will be a little bit trickier. So Audrey, can Congress require individuals to take action?
I would say no.
Why do you say no?
Because of the case from last class, the NFIB, right?
Right.
And it says that Congress can't make individuals or force them
To do what? What can Congress not make individuals do?
take action.
Specifically, what was the action in
Insurance.
buying a commercial product, right? So I think we all agree after Obamacare that Congress can't make you buy stuff. Can they make you do other stuff? Can they make you pay a tax?
Mm-hmm.
Sure as hell they can. We'll pay our taxes. Can they conscript you into the military in a draft?
Yes.
Oh, they can do that too. Can they require you to serve in a jury?
Mm-hmm.
Yeah, they do. So, can they make you take some action,
Yes, they can.
but can't make you take other action?
They can.
Yeah. So, I think actually the answer here is C. Yeah, I think that's the right answer. But I understand why you said that after the NFIB case from last class, right? Traditionally, the reason why Congress has power to regulate individuals is because they can't regulate states, right? Under the Articles of Confederation, the Articles of Government regulated the states. They asked the states to pay taxes. They couldn't ask individuals. But our Constitution flipped that. Our Constitution said Congress can't give directives to the states. Congress can give directives to individuals. And this is reflected a lot in Justice Stevens' dissent in the Prince case. He's like, of course Congress can regulate people. And then Scalia says, no. Congress can issue mandates to people in their private capacities, not in their official capacities. Yeah. So I think actually the answer is here, right? Right? And I think I can maybe frame this question differently next year, but I don't like framing it too precisely because it gives the answer away, right? It's okay. It's okay. It's why these are ungraded questions. So it's an unfair question because we haven't really addressed this issue before. Okay? But why is this framework important? Because the principles of federalism play into A and B, but they don't really play into number C. That's why I consider these separate topics for us to study. But I will make one point. In the Obamacare litigation, my colleague Randy advanced an argument which never gained a lot of traction, but I think did some work behind the scenes. And Randy made a point that the individual mandate commandeers the people, where he tried to extend the commandeering doctrine from the states, like in Prince and South Dakota or New York, to individuals that was actually commandeering the people. And that argument never gained traction. But if you read the Chief Justice's analysis, why was the mandate not a proper exercise of federal power? Because it basically told individuals what they had to buy. And Congress had never before told people what to buy. It was unprecedented, as the title goes. And that's what made it improper. So this theory of commandeering the people, right, I think affects all aspects of the NFIB case. But the more important one is federalism really only comes into play in A and B, right? Congress makes people do a lot of things, but they can't make states do things. Yes, please, Tyler.
My problem, not problem, but concern, I guess, is does it not also direct 17th Amendment direct election of senators? Is that not requiring that the state take that action?
Is the 17th Amendment an act of Congress?
No.
Right. It's a no. It's a constitutional amendment, right? Supreme law of the land. The Constitution can give whatever orders they want to the states, right? The Constitution abolished slavery. The Constitution told the states they cannot deprive people of certain rights, right? It's the Constitution that gives orders to the states and not a mere act of Congress.
So the federal government is specifically talking about congressional authority.
I'm talking about acts of Congress and the president here, not the Constitution. The Constitution can do whatever it wants.
Okay.
But good thought.
In state officials, I guess this is, I'm going to say the name wrong, the Obergefell?
Obergefell?
Yes.
The gay marriage case?
State officials issuing licenses, whether they want to or not.
Are you asking whether Congress can make state officials issue licenses?
Is that the same argument I just made on senators? Is that they just found that it was not constitutional for state officials to deny or prohibit?
You are going down a rabbit hole, but I'll follow you. So let's go to the supremacy clause. You're going down a deep rabbit hole, but I'm going to follow you there. Justice Scalia makes this point in Prince, and I highlight it in the chapter. The policies for state judges is a little bit different. Scalia says that state judges can be bound by federal law. So if you're a judge who issues a license, then you can be bound by federal law. In contrast, if you're a sheriff, like Sheriff Prince, you are not a state judge, and you cannot be bound to execute federal law. Right? Judges are in a unique position. Judges are always required to apply some other set of law and to enforce judgments. That's what they do. So according to this theory of the supremacy clause, the judges can be bound. Now, why this is a rabbit hole is that a lot of the officials who actually issue marriage licenses might be called judge, but not actually a judge. Right? They're basically clerks. They're basically executive branch official. So for example, in Alabama, where a lot of these conflicts arose, the people who hand out marriage licenses are called probate judges, but they're not judges. They're lawyers most of the time. And there was a huge question of whether probate judges, as executive branch officials, were subject to this part of the supremacy clause. I have a long, boring article on this, but it actually makes a huge difference in my mind if you're a judge or an executive branch official. So I followed you down the rabbit hole.
I mean,
it goes much deeper, but I'll stop there. I think I can still climb out at this point. I can still reach for the top.
All right.
Okay. Does that make a little bit of sense?
Yes, sir, absolutely.
Okay. Always, with 4 people, I can do whatever you guys want. I don't have to be as judicious with my time.
All right, last thing.
Yeah, go for it.
FICA and interstate highways.
FICA, the tax you're asking about, the FICA tax?
Yes.
What's the question?
It's an act.
Okay.
It's an act that requires Medicare, Social Security, federal unemployment tax participation.
It's a pay. So you're asking about a payroll tax?
Yeah.
So when you get a paycheck, they take some money off the top.
A state doesn't have the option to say we're not going to enforce this.
Why are the states enforcing federal tax collection?
They can. It's concurrent.
But are they? A better question is whether Congress can make, I don't know if it's even your reading, but there was a case in the 1970s called League of Cities versus Usury. It's referenced, yeah, a League of Cities versus Usury, which held that the Fair Labor Standards Act, that's what sets minimum wage, for example, cannot be applied to state employees. And then about 10 years later, the court reversed itself, flipped the other way. It was actually Justice Blackmun, no relation, who changed his mind. And they held that, yes, Congress can subject the state employees to the FLSA, the Fair Labor Standards Act. So there's still a lot of authority that Congress has to regulate state workers, for example. But the question I pose is, can they issue directives that take certain action? And that they cannot do. right? Like the classic example, there was an old case from Oklahoma. Could Congress tell the state, we'll admit you to the union if you move your state capital, right? It sounds like an insane thing, but the court said, no, they can't do that. All right, everyone with me? All right, so let's talk about the two cases for today. We have New York versus United States, and then Prince versus United States. And these cases are both decided within a span of about 5 years, 1992 and 1997, in a period on the Rehnquist Court that's largely known as the New Federalism. Okay, I think I mentioned this last class, maybe the class before. The Rehnquist was characterized by a desire to increase the protection of states' rights. And they did this in a number of ways. We've already studied a couple of the cases. First, they decided United States against Lopez, right, which held that the Gun-Free School Zone Act was unconstitutional because it went beyond the Commerce Clause power and the Necessary and Proper Clause power. Then they had United States against Morrison, which declared the Violence Against Women Act unconstitutional in part. We have two cases today, New York versus United States and Prince versus United States. These were cases that recognize the anti-commandeering doctrine that applies to both the state executive and state legislative officials. Your readings for Monday, which you may not have gotten to yet, but I'll preview a little bit, concern the concept of sovereign immunity. That is, the states cannot be sued by, that is, the states cannot be sued by people. There were a number of cases where the court said that Congress cannot waive, cannot abrogate, cannot eliminate a state's sovereign immunity. Right? So the effect of these decisions, enumerated powers, commandeering, and sovereign immunity, was to somewhat constrain Congress's powers and at the same time expand the scope of the state's powers. Right? These were defining elements of the so-called Rehnquist Court. I was thinking, what the hell is the defining element of the Roberts Court? Cowardice and running away and trying to not make big decisions, kick everything down the road? I don't know what it is. I was, stop calling me. I don't know how to describe the Roberts Court. They seem to just avoid every conceivable issue at every juncture. That's the best I got. But we'll see. Maybe it changes with Kennedy gone. We'll see. But Chief Justice Rehnquist is very effective at keeping sort of a path forward. Even if I don't agree with all the decisions, he definitely had a trajectory. So let's talk about the first case, right? New York against United States. Tyler, you want to give me the facts, please? That one, please.
Yes, sir. So it was a controversy, contention to this initiative to get rid of low-level radioactive.
Okay. So just let me pause for a second. Right. This is not like toxic waste that will make you grow a third eyeball, right? This is the sort of material. If you remember those old watches that would glow in the dark, right, with the little arms were illuminated, that's what we're talking about. This is not like Swamp Thing. It's not like really bad radioactive. I mean, it's not like good, but this is not going to destroy an entire world. So this is low-level radioactive waste. All right, Tyler, go on, please.
Yeah, Justice O'Connor said, that we live in a world full of low-level radioactive
everywhere.
waste, and what Congress tackled was that we only had 3 facilities in the United States to dispose of all of it for the 50 states.
That's right. That's right.
So to facilitate that, the Act provided, monetary, incentives, access incentives, but the third was the one that was in most contention was the title and or any damages or just basically control of the waste therein.
Okay, very good. We have a classic problem that's known as NIMBY. You guys know this expression? NIMBY, not in my backyard. When you study property, you'll consider this concept. Never heard this one, NIMBY? You're doing property too.
Oh.
Right? NIMBY, right? You didn't. No, it comes in property too. NIMBY, right? Why? No one wants bad stuff in their own backyard, right? Nobody wants, for example, a radioactive waste in their community, right? Who would want that? So as a result, only a couple states in the union had these facilities. Unsurprisingly, everyone wanted to send their crap to these three facilities, right? That's where we send it. And unsurprisingly, these states said, wait a minute, we are not going to have the capacity to handle 50-something states sending us their waste. Right? This is a classic, what's called a collective action problem, right? What do we mean a collective action problem? Where you have free riders. We have a couple places that are willing to bear the cost, and then everyone else just sort of mooches off them and free rides. This is a classic problem. Generally, which branch of government is best equipped to deal with collective action problems? The federal government, right? The central government. Now, the regulations in this case actually arose not because the federal government mandated it originally, but the states proposed it as a solution, right? The states said, look, we have this problem, and let's try to work together so we can all figure out some way of resolving this issue, right? Again, this was not coming from top down. This was bottom up. The states wanted to develop some sort of federal program to relieve the pressure. Right? The irony is, as soon as they developed it, they went to sue and challenge in court. Right? But we'll get there. We'll get there in a minute. Right? So, Sarosh, my friend, yes. Walk me through the different types of incentives that were put forward in this proposal to try to deal with this this problem of not enough waste dumps.
So there were three incentives. The first one was a monetary incentive.
Okay, tell me about it, please.
Basically, they would pay the states that were doing.
Well, who pays? Who's they?
So let's take New York.
Yeah.
One of the
good
parties involved, and they would pay, for instance, Nevada.
Good.
Or South Carolina.
Very good. Okay, so that was option number one, right? If New York fails to establish its own waste dump, or if they fail to work out an arrangement with these called compacts, right? These compacts are basically agreements between the states that, okay, the 5 states in this region, we will all share the waste, we'll share their costs, right? So if New York failed to build their own facility and failed to build their own compact, New York paid money to the states that were actually hosting it, right? So is there any problem constitutionally with this first option?
I don't think so.
No, right? It's basically a tax, right?
Mm-hmm.
It's basically a fee. Now, I want to make one point clear. New York State is not generating radioactive waste, right? Who's actually generating the waste? Businesses within the state, right? That's not clear from the case, right? It's not New York State as this like massive radioactive facility, right? If a New York business makes a microwave and they want to dispose of some of their waste, they can't ship it to another state to dump it, right? It's basically New York's problem. So New York would then facilitate an arrangement with Nevada to transfer it, right? That's why the states are involved, right? You can't generally ship radioactive waste across state lines without getting the states involved. So the first one is, all right, New York, you guys don't set up an arrangement, this sort of compact, you pay. And I think everyone agrees, and O'Connor would probably agree, that this is fair, right? It's, if you don't dump it yourself, pay someone else to. And I don't think anyone complained about the first incentive. All right, Lindsay, you want to tell me about the second incentive, please?
The second one was the access incentive.
Okay.
And it was if they didn't have their own, or they didn't take actions, they would be denied access to the disposal sites.
Okay, yeah, this one's also getting a little bit more severe, right? If they didn't do certain things, they would be denied access. Like, what things do they have to do, Lindsay, to get access?
Was it the compacts?
Exactly, yeah. Yeah, they have to basically form these compacts where the states work out themselves the means of actually disposing of this waste. And at that point, the states are basically screwed, right? If they don't have access to these 3 facilities, they can't keep the stuff in their own backyard. You can't just like dig a ditch in Albany, or maybe go down to Ithaca, they have these huge gorges, and just dump this crap in Ithaca, right? No one would even notice. But you can't. No Cornell's people here, right? But you can't do that, right? So that was option number 2. But again, there's no problem there from a federalism perspective, right? Nevada is not under a duty to accept waste from New York. There's no like constitutional duty to take your brother's waste. There's no like reason they have to. So if Congress says, sorry, New York, you didn't deal with your own problems, you're stuck with it, right? Figure it out yourself. Okay, but Chelsea, let's go on to the third provision, which is the most significant one, and is the subject of the case, the reading for today. Tell me what the third provision.
The third one is take title.
Okay, what is it? Take title. Did you do this in property? What does title mean?
I haven't taken property.
Is it property? What's title mean?
Legal ownership.
Very good. Yeah, the way I describe it, title describes a relationship between a person and a piece of property, right? Take title, Chelsea, means take ownership. What did taking ownership of?
The waste.
The waste, right? So let's just be very careful here, right? They were required to take ownership of the privately generated waste within the state. Okay, so let's say you're like a manufacturer of microwaves or watches, whatever else. You have some extra radioactive waste from these drums. You go to New York. Hey, New York, we want to ship these out of the state. Can you help us? And the law says, yeah, we'll help you. Bring it down to Albany, right? Bring it to the state capitol. We'll hold on to it for you. If I understand. Now, let's take a step back, Audrey. In order for New York to take title of the radioactive waste, what would New York have to actually do?
In order for them to take title of the radioactive waste.
Yes, what would New York actually have to do? They'd have to do a few things.
Wait, is it listed in the case?
It might not be in the case, but I'm asking you, right? What would the state have to do in order to take ownership of radioactive waste? Think of Texas, right? If Texas tomorrow decided they want to take ownership of all waste in the state, what would have to happen?
The state legislature just makes a law.
Well, how do they do that?
They all get in the room and
And then how are laws enacted in most states?
why don't we do this?
Generally, how is a law enacted in Texas?
The governor signs it.
Okay. So isn't that wonderful, right? Where the House proposes a law, the Senate proposes a law, the governor signs it. Now, Audrey, I don't expect you to know much about government, but is it usually that smooth?
No.
No.
It's a long time.
And are all bills eventually enacted?
No.
No.
Schoolhouse Rock, it's not.
Bingo, Schoolhouse Rock. And Audrey, I'll give you one more question and you're done. Do you think a law going through the houses in New York or Texas saying we take ownership of radioactive waste would be a popular bill?
Oh, no.
Do you think anyone would actually want to vote for it?
No.
So let's take a step back, right? New York is being told by the federal government, you have to enact this law. And the members of the state legislature say, screw you, we're not going to enact this one. And New York and the state government says, Congress says, no, we're not asking, we're telling you to go enact this law. We're telling the House members to vote on it. We're telling the state Senate to vote on it. And we're telling the governor not to veto it. You have no choice. I'm sorry, what did you say?
I said that would be an infringement on the 10th Amendment rights of the state.
Well, it's not the 10th Amendment. We'll get there in a few minutes. But I want you to understand exactly what the take title provision did. Right? It's not enough for Congress to pass a statute saying you have to take ownership of this waste. States cannot act randomly, right? They can't decide, okay, we'll do it. And let's say there's a state environmental protection agency, right? A state environmental agency cannot decide, okay, we'll just take this waste. They need law. They need a statute. They need a regulation. They need something that authorizes them to go to this building, pick up the waste, and bring it back here. Right? State agencies cannot decide to act because Congress tells them they need a law. And in order for the state to have a law, it has to go through the process. The House, the Senate, governor signs it. This provision, the take title provision, effectively commanded or commandeered the state legislature to approve a law and instructed the state governor, do not veto it. That's a serious lift, right? Again, the hypocrisy is deep because New York actually asked for this provision to be enacted. So whatever. I mean, we could dump on New York, but let me just make this point bluntly. Who cares what New York said, right? Maybe the members of the state legislature at that point were willing to sacrifice their state's rights. But there's a general principle. One branch of government cannot relinquish its own power, right? Right? One branch of government cannot relinquish its power because maybe someone in the future will want to assert it. Government cannot handcuff itself, right? A state cannot handcuff itself. So even if one state was willing to go along with this proposal, future governments cannot be bound by that. So call them hypocrites all you want. It doesn't really matter to me because what matters is New York did not relinquish its sovereignty. And Congress then can't tell the states what to do. Okay, so everyone get the three incentives and how they operate. All right, now, actually I'll go to Suresh. I'll come back to Tyler because you mentioned a minute ago. You mentioned the 10th Amendment. Suresh, my friend, what role does the 10th Amendment play in this case?
The 10th Amendment says powers not delegated to the U.S. Constitution nor prohibited by the states are reserved for the state, respectively, or to the people.
That's what it says.
Yes.
What role does the 10th Amendment play in this case?
Well, enacting laws that dictate how a state manages its low-level radioactive waste would be a power not granted to Congress nor prohibited to the states. So the states, be it New York, Texas, Hawaii, whichever state, has the right to do as they please.
And what role does the 10th Amendment play in that analysis? In other words, let me ask the question a little differently. Does the take title provision violate the 10th Amendment?
Yes.
Okay. Why?
Because it's giving Congress powers that it does not have.
Okay. You're actually answering my question in a very savvy way, which I appreciate, because most professors, in fact, when I was a student, I thought, of course, this law violates the 10th Amendment because state sovereignty. But the answer is a little more complicated. So, Tyler, I'll come back to you. I skipped over you a moment ago. 10th Amendment, right, reads very simply. It says, the power is not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people. The 10th Amendment is basically what we call a rule of construction, right? It describes how we should read the Constitution, right? It tells you how to read the Constitution. So it says, the power is not delegated to the United States by the Constitution. Okay, so Tyler, the first part, what's it getting at? Just this first, before the comma. What's that getting at here?
Enumerated. I mean, what's not explicitly.
Okay, very good. We start from the premise that all of Congress's powers are enumerated. I mean, virtually all of them are in Article 1, Section 8. Remember, they can lay taxes, they can regulate commerce, they can establish post offices, et cetera, et cetera. So the first question we ask ourselves, is a power actually delegated to the United States? Now, that's at once an easy question and a hard question. And the reason why it's a hard question is because of the necessary and proper clause. Congress has implied powers, right? They can charter the bank, they can regulate local agriculture, they can regulate cultivation of marijuana, local, right? The growing of wheat, right? They can do all these local things, but there's still some universe, it's fixed, of things that are delegated to Congress. Okay. If the power is delegated to Congress, then the states can't do it by virtue of the supremacy clause. If Congress has the power to charter a bank, then the states can't criminalize the operation of that bank, right? If Congress has the power to set a minimum wage, then the states can't put a wage below that, right? If Congress has the power to criminalize marijuana, states can't frustrate the policing of that marijuana. If Congress can criminalize anything really, the states are somewhat disabled, right? They can legislate on their own, but the supremacy clause gives higher effect to the federal law. Okay, so first we ask, is a power delegated to the United States by the Constitution? We looked at Article 1, Section 8. Okay, if it is, that's into the story. We stop reading, right? Then it's a federal power. Okay? Then we ask, is a power prohibited by the states? In other words, does the Constitution prohibit a state from exercising some power? This is a very narrow category of items. We've talked about them before. For example, Congress can't enact a bill of attainder. Congress can't issue a title of nobility. Congress can't issue an ex post facto law, right? There are some things in Article 1, Section 10 that the states simply cannot do. I said Congress, I meant states. There are some things states simply cannot do. But they're pretty few. You know, states cannot deprive someone of equal protection of the laws. States cannot deprive someone of due process of law, right? There are things they can't do. But generally, the state police power is pretty darn broad. All right, so we ask, does Congress have this power? No. Are the states prohibited from doing something? No. Then we get to the last part, and that power is reserved to the states or to the people, which is an important part. So let's consider radioactive waste regulation, right? Specifically, what's our power? Take title of radioactive waste. Does Congress have the enumerated power? It's for Lindsay. Lindsay, does Congress have an enumerated power to tell states to take ownership of radioactive waste?
No,
Okay, how do we know that?
it's not in Article 1, Section 8, and it's not prohibited in Article 1, Section 10.
Okay, we'll get to Section 10 in a minute, right? But why isn't the take title provision an implied power? So let me ask this question a different way. Does Congress have the power to regulate the movement of waste across state lines?
Yes.
They do. We all agree with that, right? Could Congress say that when you ship waste, you have to use certain types of containers and certain safety things, right? You know, you want to spill waste on the highway. I think it's probably a good idea, right?
Yes.
Okay. What if Congress says, we are concerned that our federal scheme of interstate waste transfers will be undercut, will be frustrated by New York keeping everything local and not disposing of it properly? Couldn't Congress say, in order to prevent this colossal disaster, like this ecological disaster in New York, we're going to make New York take ownership. We don't want people dumping in the streets and the highways and the streams and the waters. Why couldn't this be a necessary and proper way for Congress to regulate the interstate waste market?
So it would maybe be considered necessary, but it's not proper.
Bingo.
There would be other means that New York or the federal government could impose upon New York to pretty much achieve the same goal.
Very
without
good.
Commandeering New York's legislation.
Okay, so I think we can all agree that it is necessary, that this is a useful way for Congress to act under McCulloch. But how do we know it's not proper? Chelsea, how do we know this is not a proper law? Where does O'Connor's majority opinion tell us this is not proper? How do we know this is not proper? It's not in there. It's not in your federal power. Okay? Okay. I'm actually going to make a note about the wireless because it's very slow and my stream is not working. I'll make a note to email them later after class. Okay. This thing keeps dropping off. Sorry about that, people watching at home. Everyone get that point, right? The reason why Congress cannot intrude is because it's not a proper exercise of power. So really, the 10th Amendment says, is this power delegated to New York? No. I'm sorry, damn it. Is it delegated to Congress? No, it's not. I said the wrong thing. I jumped ahead. Is it power delegated to Congress? No, it's not. Does New York have the power to describe how waste is controlled? Yeah, they do. That's their police power. And nothing in Article 1, Section 10 is to the contrary. The states have the police power to dictate how waste within their borders is managed. Okay? Everyone understand? So really, one second, OJ, I promise. Really, what this case is about is asking, does Congress have the power to enact this law? They don't. Because the power to regulate waste really belongs to the states and to the people, right? The people of New York get to decide how waste within their own state is managed. Now, if Congress passed a law saying that private businesses that have radioactive waste have to dispose of it in a certain fashion, that Congress can do, right? That's like RACH, right? That's like Wickard. Local activity that's economic in nature, which has a substantial effect on interstate commerce, can be regulated. But because the law is acting not on private individuals, but state legislatures, you have a problem. I knew it. See, you just gotta wait. I usually do. It's not a boast, but when you teach this case enough, I anticipate the questions in advance, so I just answer them and cut them off. It's amazing how predictable students are. I don't mean that as a pejorative, because the mind works in a certain way, and people actually usually ask the same questions at the same junctures. Like, for example, my Obamacare talk, I can usually predict the first 3 questions in a room almost to a T. Out of order, perhaps, what the first 3 questions will be. But you did enough, you figure it out, which is a compliment, right? You're thinking the same way that students are thinking before. I think it's a good thing. Okay, so Justice O'Connor's opinion is truly a discussion about state sovereignty, right? It's the federal government, and they can't tell the states what to do. Okay. I think I'm done with the majority. I think I got everything I need to do. Okay. Any other questions on the majority opinion in New York? Yeah, Tyler?
So you said something, you said more to the people was particularly important.
Yeah.
Was the reason, I don't think she talked about it.
Nope.
Is that what made the governors and whomever, senators, representatives vote, not necessarily a state's endorsement?
Yeah.
Is it?
Yeah, I mean, who does a governor represent? It's the people, right? Who does the state legislature represent? They represent the people of the state. I think what that part of the 10th Amendment is reflecting is ultimately the power belongs in the individual. The individual is the source of power. You'll read a case from Monday, which I don't know if you read yet, called Chisholm versus Georgia. Haven't read it yet? No, okay, it's from Monday. We haven't got there yet. But one of the questions in that case is, where does sovereignty belong? Where does the power belong? And the court split, and 4 justices said that in our republic, the sovereign is the people, not the states. And the one justice in the dissent said that the states are sovereign. That one justice in the dissent prevailed. And under modern constitutional law, states have sovereignty, not individuals, which I think is kind of backwards, but the court doesn't agree with me.
And I thought you were going to say this earlier when you were asking Audrey about laws and things like that. In the Ashcroft case before, they talked about, is guarantee clause, is that appropriate?
We didn't sign that case. You read it anyway?
Yeah.
Is that inadvertent?
It's right in front of the other one, so I assumed it was there for a reason.
Yeah, Randy assigns it. I don't. It's an older case, but yeah, it's a good case.
So when they talk about a Republican form of government, is they're saying that, okay, so we're not just saying that these are some incentives, the monetary and access, but you have to make a law telling them to go through the process that you described. Is that guarantee clause not an easier win for a majority decision?
All right, so let me take a little bit of a detour, not too deep of a rabbit hole, but I'll go a little bit. There's where is it, Article 6, I think? An article, the guarantee clause. 4, thank you. Article 4, Section 4, thank you. I'm embarrassed I didn't remember that, right? Article 4, Section 4 says, the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and an application of the legislature or the executive when the legislature cannot be convened against domestic violence. This is one of the more enigmatic provisions of the Constitution, and there's virtually zero case law about it. And I'll give you an early story or an early incident of where this case actually arose. The case is called Luther versus Borden, B-O-R-D-E-N, Luther versus Borden. And there was basically a coup in, I think it was Rhode Island. You can check me on that. I think it was Rhode Island. And there was a debate. There were two groups who were both claiming to be the lawful governor of the state, right? One guy said, I am the real government. And the other guy said, I'm the real government, right? And this dispute made to the Supreme Court. And the Supreme Court was asked to decide, you know, who was the real governor, right? Who was the real government? And the gist of the case is that the guarantee clause is something for Congress to decide, right? Congress can decide who the correct governor is. It's not for the courts to decide. Now, that case is very controversial. I don't want to go too far into the weeds. I think it's probably wrongly decided. But the guarantee clause means you have some sort of representative form of government, right? Republican doesn't mean like GOP. It means like a representative form of government. But the failure to provide a Republican form of government is generally thought to be something that only the Congress can address. That if a state fails to give their people a Republican form of government, then Congress can step in and do something about it. Now, I don't think this power has ever actually been used. The Republican part, Congress has put down insurrections. That's happened before. But it's an important power. Now, would commanding the states to engage in a legislative action, would that violate the guarantee clause? I don't think so. I don't. It's not quite what the guarantee clause describes, but it's in the ballpark of generally Congress has to be very delicate in giving any orders to the states, right? They can give orders to the states when there's a time of insurrection or violence, not like in general, mundane, boring things. Does that kind of answer your question? Yeah, it's the guarantee clause is something that I've not given enough thought to. Maybe I should give it more because this doesn't come up much. But yeah, it's in there. It's in the Constitution. It's all in there. Don't forget it. All right. Any other questions on the majority opinion? I never remember. Is the white opinion in your book or not? I always remember. Okay, the white. It's like it's in my head, and like I never remember if it's in your book or not. Justice White was a Kennedy appointee. He was a remarkable guy. He played football in the National Football League and went to Yale Law School basically at the same time, right? He basically went to a year of law school, took a year off to go play in the NFL, and later finished his law degree. Right? I mean, he was an amazing guy. Did he win the Heisman? I'm not sure, but he played football at Colorado, and he was like this huge. The guy was huge, and he later went on to serve in the Kennedy administration, and JFK put him on the U.S. Supreme Court. He was a Democrat appointee, quite liberal but very pragmatic, and he had a few conservative streaks. One thing, he dissented in Roe v. Wade, and a few other cases involving right of privacy. But he was also very pragmatic. He didn't stand on formalities like I do. Right? He was very much interested in making government work. He was very much like Justice Breyer, who we have in the court now. And Justice White basically says that the states agreed to this deal, right? We have a national problem. And New York has reaped benefits from this plan. There's nothing wrong with this. Okay. Justice Stevens, who gets very agitated in Prince, he's sort of like okay here, but you can see in Prince he gets really pissed off. Here he's basically saying, of course Congress can issue commands to the states, right? That was the entire reason why we have a constitution. The federal government can exercise legislative authority, and there's really nothing wrong with this. He also says the 10th Amendment places no limits on federal power. That doesn't quite get it right because it's not the 10th Amendment, it's the doctrine of enumerated powers itself that matters. He also raises an example which he visits in Prince, that in times of war, Congress can draft soldiers and command states. And Scalia actually responds to this in Prince as well. No, they weren't actually commands, they were actually requests. It's the difference between give us soldiers and would you please give us soldiers, right? Is it actually a request or not?
They were paid, right?
I'm sorry?
They were paid, correct?
Right, but the question is whether the president could command the governor to hand over state troops, like state officers.
Is it weird to ask how Justice O'Connor over the years, how she voted normally on the Supreme Court? She was nominated by
Reagan.
Reagan.
She was, she wasn't,
Did she like always sway one way?
she was for many years known as the swing vote. That was often what her reputation was. However, and this is a big however, she had a very moderate streak. Her background was in state government, and she would often find a way to vote in the middle. And this was much to the frustration of conservatives at many junctures in her career. She we'll read this later this semester. She voted to basically reaffirm Roe v. Wade, even though most of her conservative colleagues didn't. Then she also voted in Bush v. Gore to halt the recounts in Florida. She voted to uphold affirmative action, but she voted to strike down the Gun-Free School Zone Act. She was, in many regards, the type of a moderate that doesn't exist on the court anymore. She was very unique. Again, Reagan picked her. She had a background in state government. But we don't have a Justice O'Connor anymore. We don't have a Justice Kennedy anymore. But she had a strong independent streak. It's hard to typecast her because she was all over the place on a lot of different issues.
Yeah, because her opinion here, and she seemed pretty good at explaining it.
Yeah. I think you read her South Dakota v. Dole opinion. You read her majority opinion in New York. I think she had a concurrence. She read her dissent. She dissented in Raich as well. I think what other O'Connor opinions do we have? You'll read her opinion later on affirmative action in the Grutter and Michigan affirmative action cases. You read O'Connor on abortion as well. We have a bunch of O'Connor opinions. Yeah, she was pretty influential for her day. She's quite ill now. She's did they tell you about her husband and the senility? This part's kind of sad. So she announced her retirement in 2005. And then a couple months later, Chief Justice Rehnquist died. So basically, George W. Bush had originally nominated John Roberts to fill the O'Connor seat. But when Chief Justice Rehnquist died, Bush slotted Roberts into the Chief Justice seat. Right? And then he put eventually Justice Alito to replace O'Connor. So Bush got basically 2 picks in the span of a few months, which was rare. O'Connor stepped down fairly young because her husband had a senility, basically dementia, and she basically retired to take care of him. Remember, she turned Rehnquist down for John O'Connor, and this is the sad part. Her husband basically lost his memory and forgot who she was. My grandfather had very bad dementia later in his life, and he went pretty quickly. Within a year or two, he was gone. But O'Connor's husband lived for, I think, almost 5 or 10 years with dementia. He was living in a home. He actually found a new girlfriend, which it's a heartbreaking story because he didn't know who she was anymore. So O'Connor left the most important job in the world to take care of her husband, and he forgot who she was. And now O'Connor herself, in the last year, has announced that she's basically withdrawing from public life because she has some form of dementia as well. She's losing her senses. So it's very sad. These people are so important, and you read their opinions, and then they're sort of gone. And the question is, how long do we keep reading these opinions after these people are off the court? Because, ConLaw casebooks, they change a lot. Property casebook, torts, things don't change. The same cases for 300 years, right? These cases don't ever change. Pearson v. Post will be around forever. Hadley v. Baxendale will be around until eternity, right? But ConLaw cases, we do. For example, I want to cut Gregory v. Ashcroft from the book. Randy won't let me. Maybe in the next edition we'll see. I just don't think it's relevant anymore because O'Connor's not here. I cannot wait to cut O'Kennedy opinions. Oh, I'm having the red pen ready to go because he's gone. But I mean, some opinions are forever, right? The Holmes opinions were stuck with us forever. I think opinions by John Marshall were stuck with forever.
What about Scalia?
I think Scalia is going to be up there with Marshall and Holmes. I think we're reading his opinions 100 years from now. I think he's the only justice that anyone will even know about in 100 years. The same way, can you name any justice in the early 20th century other than Holmes? Oh, Cardozo, he's one. And in fact, Cardozo was more influential for her state court work in the New York Court of Appeals than the Supreme Court. Do you even know he was on the Supreme Court? No. He was in the majority in Schechter Poultry. That's about it. He didn't do much in the U.S. He wrote Erie. That was a big one. Or was that Brandeis? No, Brandeis wrote Erie, I'm sorry. Yeah, but I mean, most justices, they're not very influential. I think Justice Thomas may have some longevity. He has a lot of very big dissents. But I think the current batch, they'll be edited out. I mean that so sincerely. Justice Souter, for example. Oh, this pisses me off. He put his private papers, to be held secret for 50 years after his death. He's in his 70s. He's doing great. So, his papers may not be available until I'm in my 90s. Right? It's just he said, I want people to read these when I'm long gone and forgotten. I was like, it won't take that long, David. It's already happening. But yeah, it's they live on in their opinions, but we're all men are mortal. Yeah, I think about that a lot of stuff because it's which opinion will still be here in 100 years? God willing, I'm teaching in 2076. What am I going to be teaching? Okay. Oh, Lord help you all. Lord help you all.
Ginsburg will still be there.
She'll be 150. Still doing push-ups, beating me and planking. All right. Anything else on New York? Very important case. All right. Let's do the next case, Prince. Now, keep in mind that Prince was decided in, was it 96? 97. 97. When Prince was decided, the Second Amendment was still sort of in flux, right? The federal courts had not held, at least the Supreme Court had not held, that there's an individual right to bear arms. So as of 1996 or 97, there was no really good way of challenging the gun control laws at issue in Prince as a violation of the Second Amendment. But make no mistake, this lawsuit was backed by the NRA. Sheriff Jay Prince is a board member of the NRA. This was an NRA lawsuit. And instead of relying on the doctrine of the Second Amendment to challenge these handgun laws, they relied on the doctrine established in New York versus United States. Okay, all right, I'll start the facts. Who's next? Okay, yeah, go for it. Soros, you want to tell me, please, the facts in Prince against the United States?
Yes. So basically, this was the Brady handgun.
By the way, everyone know who Brady is? You know who he is. Who is Brady?
When he was shot in Reagan's assassination attempt.
Yeah, he was the press secretary in the Reagan administration. And John Hinckley, right? Yeah, John Hinckley was an assassin who almost killed President Reagan, but he also shot John Brady. They were at the Washington Hilton in D.C. And the gun control group, they've changed their names nonstop. At one point they were called the Brady Coalition to Prevent Handgun Violence. Now they're just called Brady. Period. They're just Brady. But they're named after him. All right, Soros, go on, please.
Yes. So this was a congressional act which wanted to give chief local law enforcement officers, like the sheriffs and like police chiefs of local agencies, power to conduct background checks
Well, not just power.
Or,
What exactly did the Brady Act state? It wasn't just they have the power to conduct background checks.
they actually had the, what was it, each of the but, I read it too, so they were compelled to.
Compelled, thank you. Yes, sir, that's correct. This wasn't giving state sheriffs the power to perform background checks. They can do that anyway, right? They didn't need permission. If a CEOs of every jurisdiction to perform a background check before someone's allowed to acquire a gun. And the process is a little bit intricate. To engage, right? The CLEO is required to perform this background check to determine if there's any violation of the law. Okay? And if the CLEO tells the gun dealer that he's ineligible, they must give a reason why. All right, everyone understand just how this regime worked. All right. This was only a temporary measure. The federal government was designing what's called NICS, the National Instant Background Check System, right? If any of you walk into a store today to buy a gun, you will fill out a form. The dealer will run your name through a database, and it comes back in a few minutes, yes or no, right? That database did not exist in the 1990s. So this CLEO approach was meant as an interim measure, a stopgap measure. Until the federal database was built, we would use local law enforcement to perform these background checks. Everyone with me? Now, Lindsay, what could Congress have done instead of ordering the sheriffs in these counties to these background checks? What else could they have done, perhaps?
You mentioned something about them maybe sending ATF agents to each of these places and having them do the background checks?
Yeah, send a federal agent to every single county in the United States to be able to accept these forms. There's no email. I guess maybe fax would work, right? Have them faxing these forms to the federal bureaucrats somewhere, and they'd run background checks. Now, let me ask you, Lindsay, what do you think would have happened if a bunch of federal ATF agents walked into Ravalli County, Montana, checking up on people's gun purchases?
The sheriff is not going to like that.
There will be blood, right? I think it'd be very bad if that happened, right? I think everyone would at least agree with me on part. So in one regard, this was less offensive, right? Rather than sending in federal agents to the local counties, they said, we'll use your existing people. And Sheriff Prince can do it, right? Now, Sheriff Prince was a big guy, right? I put pictures of him in the video. This guy he looks the role. In fact, he was not only the sheriff, he was also the coroner, right? That's how small this town was. They had one guy who was both the sheriff and the coroner. He would, do the, what do you call them, the autopsies, for the dead bodies, right? Actually, I don't know if he did autopsies, but at least he helped dispose of the corpses. So this was a small town in Montana, Ravalli County. The other one was actually Sheriff Richard Mack from Graham County, Arizona. Funny story. Years ago, I got an email that blew from Sheriff Mack, who insisted that the case be called Mack versus United States and not Prince versus United States. Why? Mack, M, alphabetically, comes before Prince, P. I explained to him, no, that's not how it works. The case that files the appeal first is listed first, and Prince filed first. Okay, whatever. You live and learn. But these two sheriffs challenged it, and they made a couple arguments, right? Chelsea, what was I forget their legal arguments, but as a factual matter, why were these sheriffs unwilling to do these things? What was their objection?
They didn't want to delay the locals.
Yeah, that's a biggie, right? These are fairly big Second Amendment supporters. They did not want to have to delay their local residents from buying a gun. Now, Chelsea, let's just think about this here, right? you're a resident of Montana, you walk into a gun store and you say, I want to buy a gun. And the sheriff says, okay, check back, Sheriff Prince, give me 5 days. What do you think the local resident's going to think at that point? Why aren't they getting a gun? Whose fault is it?
The sheriff.
Sheriff. Not Congress, the sheriff. And this is an important point. There's a concept called political accountability, which comes up in a few of these opinions, right? When Congress imposes mandates to the states, it blurs who's actually accountable. For example, if the New York legislature and the New York governor approved this take title law, the people in New York wouldn't blame Congress. They'd blame their own governor for voting for this, might throw the bum out of office. If a resident of Ravalli County, Montana can't buy a gun for 5 days, they're not going to blame Congress, they're going to blame the local sheriff. So basically, Congress is shifting the blame for unpopular policies from the national government to the local government. Everyone understand that? Right, and this is an important point that comes up both in New York and in Prince, that the power to commandeer distorts it. I'll give you another example that I alluded to in the last class, which is that of sanctuary cities, right? If Congress can tell local law enforcement to turn over certain immigrants in your custody, who are those immigrants going to blame? Congress, the local law enforcement. Who are the family members, the community members going to blame? Congress, the local officials. Local officials, right? So the entire idea of commandeering blurs or distorts who's actually accountable or responsible for certain policies, which is why one of the animating principles of the commandeering doctrine is make it clear if you want federal officials to run a background check, you put an ATF agent in this city, right? You send a federal ICE agent to pick up this person.